This conference will now be recorded.
Okay, so I think I can start with a super short introduction and then we kick this off. So for those who don't know me, my name is Virginia and I am the coordinator of Eumans, which is a very early stage European movement which aims to improve the life of Europeans committed for the ecosystem and democracy and better quality of life. And as part of our initiatives, we joined the European Citizen Initiative launched by Virgilio, Dastoli and the European Movement for the respect of the rule of law in the European Union. And tonight we wanted to gather experts, academics and activists across Europe to start to discuss together a bit more in depth about the current instruments available in the European Union for the rule of law, but also the new tools recently unveiled by the Commission, and also discuss together a few specific cases on how the rule of law in Europe is under threat. I'm super happy that we have Wojciech and Malgorzata from Poland because it's one of the unfortunately famous country on the topic, and I think hearing their stories and their voices is really, really important to get a sense of the issue that we are tackling with the European Citizen Initiative. The structure of the event is that we're going to have a first round of short speech from the discussant, and then there's going to be plenty of time for questions and dialogue. On the right side of the screen, you should have a control panel which allows you to write in the chat. So if you want to say that you want to have a question or something, just drop it down and take notes. So to kickstart this, I think the first two people that needs to welcome us are Virgilio Dastoli and Marco Cappato, because they are those who launched this initiative. So I would like to introduce you, Virgilio Dastoli, from the president of the European Movement, for a short intro about how you came up with the idea of the European Citizen Initiative on the rule of law and the sense that this initiative is getting now that the Commission itself and the Parliament are kind of active on the topic. So, Virgilio, you have 8 minutes for an intro, and the floor is yours.
Yeah. Thank you very much. The European Movement decided in February to submit citizen initiative to the Commission, the 8th of February, and 8th of April, the Commission accepted the juridical basis that we put in our citizen initiative. That means the Article 70 of the Treaty on Functioning of the European Union. That is an article in the framework of the title concerning justice, freedom, and security. More or less in the same days, the 3rd of April, the Commission submitted a communication on the few steps of the rule of law. Following this communication of the 3rd of April, the Commission accepted our proposal the 8th of April. The Commission launched a hearing addressed to the stakeholders, and the Commission received more or less 60 opinions from governments, from civil society organizations.
Virgilio, stop the video. Stop the video, Virgilio. We cannot understand.
Have the possibility to start from the 8th of April to record the signatures. As Virginia said, the 17th of July Commission the possibility to submit to the Parliament, to the Council document. Timmermans. You cannot? Hello?
Yes,
Hello?
we can hear you. Not very well, but
Hello?
we can hear you.
You listen me?
Virgilio, stop the video.
Hello?
Keep just the voice, not the video camera.
Hello?
We can hear you.
Hello?
Ti sentiamo.
Hello?
Virgilio?
Yeah. I used the taste on my iPhone.
Perfect. Vai Virgilio, puoi parlare.
So this. Hello?
Ti sentiamo, puoi parlare, però non devi usare la telecamera del telefono. Parla e basta.
I stop. Sì? Io vi sento.
Vai, parla.
Non so come si fa.
Virgilio, se parli ti sentiamo.
Allo? Vi sentite?
Sì, ti sentiamo.
L'ho tolto.
Ti sentiamo, parla, ti sentiamo bene.
Penso la tolta. Così. Ecco. Sì. So I just the not legal proposal. Mi sentite?
Ti sentiamo solo quando dici mi sentite, quindi...
Allora, io sto parlando. Pronto? Allora?
No, io direi andiamo avanti, Virgilio, riproviamo dopo, non si può.
Okay, let's switch to Marco Cappato, and in the meantime I'll give a call to Virgilio.
Yes, okay. Can you hear me?
Pronto?
Okay. Virgilio,
Pronto?
I start and then you try to fix your connection, because if not, it's completely useless that you speak and nobody understands. So, hi to everybody, hello to everybody. Thanks for being here tonight, this evening. Unfortunately, I would have needed to have the introduction from Virgilio before than me, because he knows much better than me the technical stuff. And in this case, talking about rule of law, technicalities are very important, or maybe are the most important. So my introduction is just complementary to the content of the European Citizen Initiative. And I just wanted to underscore the political importance of this initiative at this particular moment. As you know, the designated European Commissioner, Ursula von der Leyen, included in her speech to the European Parliament exactly the issue of the rule of law as one of the priority, and immediately a communication which was already ready before, of course, from Commissioner Vice President Timmermans, has been published. And so this is, I would say, is a proof of the will from the European Commission to do something about the rule of law. We don't know yet what this something will be. It could be a very strong binding mechanism. We don't know. Basically, we can just have a speculation. Also, because the Commission cannot act by itself. The Commission needs also the Council and the Parliament to go ahead. Our proposal, apart from the very ambitious goal of collecting 1 million signatures around Europe, our proposal has also the ambition to reinforce the political message for the need of such measure from the European Union. There are some particularities that make a difference among between our proposal and the proposal from the European Commission. For example, I see Filippo Di Robilant there, the explicit involvement of the Fundamental Rights Agency, and in particular for the need to have independent and systematic approach in monitoring the rule of law situation around Europe. What is very important for me is that in this field, we know that we have experts at the European level about the rule of law and about what the European Union can do. And some of them are attending this meeting. So thank you very much. On the other side, there are a lot of human rights defenders around Europe that they are doing their job without expecting much from Europe, because until now, the European Union has not been very effective in helping or in intervening in national situations. Our campaign has also the purpose to change that, to create a European network of activists and organizations that keep on doing their own job in a completely autonomous way. So we don't pretend to make an umbrella organization because there are organizations that are working since decades and more effective than us. So it's not we don't have to create a meta organization. I think we just need to reinforce the synergies, the common action, and the coordination among national groups. So and there again, having the Fundamental Rights Agency as body that we chose as the one that could cooperate to reinforce the rule of law control by the European Union is also a way to create and reinforce this kind of European network, because NGOs are already cooperating since years with the Fundamental Rights Agency. So I think it could be already this place, this site, the place from which we could start. Unfortunately, the mechanism of authorization of the website and so on took a lot of time. So we already used some months of the year that we have, but I think that we can still do a good job in connecting organizations and people that are defending human rights in their own specific field. That could be prison, justice, LGBT rights, or patients' rights, or whatever, and try to make them act together on the idea that the European Union can help their own specific purpose, linking them together to other initiatives and other groups. This was what I wanted to say as an introduction. Thank you very much.
Thank you, Marco. In theory, the next on stage will be Annalisa Angieri. So if she's quick, she goes first, and then we have Jesse Colzani from the Good Lobby. So go, Annalisa, about the European instruments.
Hi, I switch off the video. Okay, can you hear me?
We can hear you fine.
Okay, good evening, everyone. I'm Annalisa Angieri. I'm gonna chat with you about existing likely future tools, let's say EU instruments on how to prevent or to respond to a breach of rule of law. Before making a list, a few points. First, communication are not weekly newsletters, of course. This is for non-experts, sure. But the EU commissions, this communication are not directives or proposals. So we have to wait for proposals. Likely we'll have further communication. We'll see. We'll see. Article 7 at the moment is the only coercive and concrete instrument we have for serious cases of risk for rule of law or persistent breach of rule of law. All other instruments, included the incoming/foreseen tools, refer to a preliminary phase. That's my point of view. They are made to prevent, to get to Article 7 and to treat Article 7, which is politically a complicated issue. And then it confirms that Article 7 is an extrema ratio and it is rarely used like today. By the side, the asset will be the same, and maybe only one instrument may be involved in the Article 7 situation as a new one, according to the last communication, July 17. Interim measure for specific situation, but still, we'll see. If we have time later, it can be interesting to talk about Article 7 and about the vote system related to Article 7. So let me know if I have time later. Let's make this list. It may be a bit technical, so please don't fall asleep. We'll have a rule of law review cycle, including an annual report. This I think for sure. We have this, and an annual event on dialogue with civil society, and then media, member states, parliament, academia, education systems will be involved, as well as judicial network, lawyers association, presidents of Supreme Courts. That sounds interesting. And also network of national contact points as a brand new instruments. EU political parties and their pan-European programs as well. I feel involved. Before completing this list, allow me some consideration. Apparently, the European Commission in this last two communication is focusing on judicial systems, on how to figure out lack of an effective judicial protection, impartiality, independence of judicial system. Signs to check that have been already mentioned in the communication of April. The increasing use of executive orders by the majorities or government statement on judicial system, judges, etc. This because justice is the concrete expression of rule of law. And it's definitely interesting the involvement of financial interests of the European Union, sorry, in the picture, and the work of the Office of the Public Prosecutor, finally operational at the end of 2020, and the deeper cooperation with the Council of Europe. Well, of course, the importance of the European Court of Human Rights, its judgments will be relevant as standards for the Union, for member states, not only for the definition they give, but as standards. I conclude the list. In the annual report I mentioned, we will have member states' situation on rule of law, case law I mentioned, of course, the EU semester country report. So tools, instruments, we already know. EU Justice Scoreboard, which is a document on comparative data and independence, quality, efficiency, according to the framework of 2014. And European Parliament and Council debates and discussions. Also, other European institutions may be involved, like, for example, European Economic and Social Committee. To conclude, the issued documents make me think of an action some way necessary. Also, the statement of Franz Timmermans make me think that an intervention, an action is necessary. And what do you think? Maybe the framework of 2014 is a failure or not? Thank you very much.
Thank you, Annalisa. If Filippo is patient, I would now have Jesse Colzani, legal matchmaking officer at the Good Lobby. He was supposed to talk later, but he has some things going on in Bilbao. So Jesse is going to introduce us to the tools that are available for the citizens. So what a citizen can do in the context of the respect of the rule of law. So welcome, Jesse, and you have your 5 minutes.
Yeah, hi everybody. Thank you very much. And apologies, but I really have to go back to the summer academy we're running here in Bilbao. So I wanted to briefly introduce you to my organization, to the Good Lobby. The Good Lobby is a civic startup with the goal of demystifying and democratizing lobbying, making it accessible to civil society. We were founded in 2015, and we slowly started growing. Now we're a team of 8. We initially were just volunteers, but we started getting funding, and now we're all paid employees. We have trained more than 2,000 citizens in the past years, running 40 workshops all across Europe. A lot of those were in countries where the rule of law is particularly a sensitive issue, specifically Poland and Hungary. And we have a quite good network of law firms and lawyers. So what I specifically do is match civil society when they have some legal needs for their advocacy strategy with legal experts, specifically law firms, lawyers, and academics. And by connecting them, we create a quite good impact that otherwise wouldn't be achievable. And one of the instruments we usually point out to citizens in our workshops and in the resources we make available for them is the ECI. But there are a lot of other instruments, such as the Freedom of Information Acts that are regulated by the different legislations all across Europe and across the world, or complaints to the Ombudsman, Mediatore Civile, Mediatore Civile in the different jurisdictions, or the various strategic litigation avenues, which can be feasible even for citizens who are not very well organized, by indeed having some pro bono lawyers that can help them with this strategy. Since I see that Laurent Pech is connected from London, I also wanted to mention this procedure we have been activating in the past year with the European Parliament. Maybe he's gonna talk about it more later. But specifically, there is a regulation that allows 50 citizens to request to the European Parliament to verify the compliance of European registered parties to the values of the European Union, specifically Article 2 of the Treaty on the European Union. And the European Parliament has been kind of stopping us from doing this, preventing us from doing this by using some very particular argumentations. And at the moment, there is a pending complaint before the European Ombudsman. But if we or other 50 citizens manage to get this request approved, this would potentially mean the deregistration of European parties that do not comply that are not in compliance with European values, and the rule of law. So this is a little bit an idea of the tools that citizens have available, and we try to promote them as much as we can, running workshops and presenting our work. So do not hesitate to get in touch and ask some other questions if you have any of them.
Thank you, Jesse, for the introduction. And since you're gonna leave, we will reach out with questions in case.
I'm still gonna listen. I'm still gonna listen a little bit, but then I'll leave.
Well, thank you very much. Okay, so now it's time for Filippo Di Robilant. Filippo works for the European Agency for Fundamental Rights, European Union Agency for Fundamental Rights, and so he's gonna talk us a bit about his organization itself, and then his feedback on the communication from the European Commission. So, Filippo.
Thank you very much, Virginia. I hope you can hear me. As you were saying, I'm a vice chairperson of the management board, which is a 5-year mandate, and my mandate expires in 2020. So what I would say is a few words about what FRA does, and then a few words of comments on the Commission communication. So FRA was established 12 years ago to provide independent, evidence-based assistance and expertise to EU institutions and member states in order to ensure that fundamental rights of people living in the Union were protected and that the EU Charter was applied. What does FRA do? Large-scale surveys, comparative legal or social research, handbooks for legal practitioners. Within what we call a multi-annual framework, which is a bit of a straitjacket, I will tell you later. This multi-annual framework is negotiated between Council and Commission, and it contains 9 thematic areas. I won't list them all, but they go from the A of access to justice to the X of fight against xenophobia. It works with all relevant institutions and organizations on levels, from EU institutions to national bodies and civil society platforms. Its budget is more or less 21 million euros, which means for each European taxpayer 4 cents a year. For me, what is the added value of FRA? It's high quality research, it's pan-European approach, it's rights holders focus, it's outreach to civil society, its independence, of course, this is what I value most highly, and its vision, philosophy of not only looking at EU law, but also at international law for implementation. Now, what are its shortcomings? It has a limited mandate, what I call the straitjacket before, made of procedures and regulations, and it has a longer list of things that it cannot do. I think there's an interference. I hope you can still hear me. You can hear me? Hello?
Yes, we can. There was someone.
Okay, good. Okay, it was an interference. So what I was saying is that it has no right of initiative, it has a very slight margin for proactiveness, it has no sanctionatory powers and no naming and shaming, no whistleblowing. So it needs in some way to be enhanced in the future if we want to make the new rule of law framework really work, and I think the ICE is going in that direction. Now, I'd like to make a few comments on the communication, but please tell me if you can hear me properly, yes?
Yes, we can hear you perfectly.
Good. So, what do I take away from the communications are 2 important elements. First, the Commission is clearly leveling up its monitoring role, and secondly, the Commission admits that the problems are part of a cultural issue that can only be addressed from below, which implies that many more actors have to get on board. There is a strong recognition of national parliaments, media, civil society, networks, etc., and cooperation with other actors must be explicitly welcome. The big challenge that I see now is how to best bring this initiative and all the different avenues that are opening up into one systematic and synergetic picture. I mean, for instance, the European Parliament EDF Pact, the intergovernmental proposal by Belgium and Germany, the reform of the Council on Rule of Law dialogue. As regards to the reference to the agency in the communication, on one hand, the reference can be considered robust, knowing that Commission would avoid anything that could only slightly make people assume that Commission is not totally free in selecting the evidence they're basing the assessment on. EFRIS, the European Fundamental Rights Information System, proves to be a modest but efficient entry point into this debate, which is not only politically speaking loaded, but increasingly overcrowded with ideas and approaches. But because it is a communication and not a legislative proposal, as Annalisa was saying, I think the Commission could have been bolder and gave the agency a bigger role than just, I quote, a source of information among many other bodies. As far as the question, is ICE with this communication exceeded in any way? My answer is no. The ECI has two dimensions. One is the laying down of arrangements to, I quote, to conduct objective and impartial evaluation of the implementation by national authorities of the Union policies in the area of freedom, security, and justice. And I assume that this is about a commission-driven peer review process to be established under Article 70. And such a mechanism would for sure be useful, especially if it would build on or at least take into account findings of the other fora that exist or are developing. At the same time, an Article 70 peer review mechanism would have a limited scope, that is the implementation of existing EU legislation. The second dimension of the ECI is the reinforcement of the agency's founding regulation. Now, of course, here views might diverge. What actually the most useful element would be in the context of the rule of law debate. One could say that an explicit mandate to monitor member states in a country-by-country manner would be important. Some would disagree and argue that this is already possible. Others would say that FRA should be entitled to have a consultative role under Article 7. Again, some would argue that EU institutions, if they really wanted, they can already consult the agency under its present mandate. Again, others would say that the scope of the agency's mandate needs to be extended to areas beyond the EU law, so to be able to provide regular evidence for the Union to monitor prior Article 7 situation. So to finish, again, others might say that there's not so much a need to strengthen the agency vis-à-vis member states, but rather vis-à-vis the EU institutions. So to signal that the rule of law debates is not only about member states, but also about the EU itself. In this context, allowing FRA to submit own initiative opinions on draft EU legislation would be very helpful indeed. So these are my first comments to the communication I had the chance to see very quickly this morning, and I hope this was helpful for the moment. Thank you very much.
Thank you very much, Filippo. We wait for Virginia for the next speaker. And
sorry, I had guest invested, so two people are joining. Who is introducing someone, Marco, or shall I?
Let's go.
So we have Laurent Pech. I say Pech, but it's Pech, I think, from the London meeting point. And we're super happy to have Laurent. I had the chance to hear him in Brussels and was quite an experience. So I hope he's gonna rock us.
Yes, we have quite a crowd here in London, so make some space for Laurent too. come closer so you can hear him better and see him better.
Thank you very much, and Santé to you. Best greetings from London, where the weather is very nice. So I'm going to use my 5 minutes to possibly explain what we're trying to address and possibly what we can do about it. So what is the nature of the problem we're trying to address? I call the problem we are trying to address rule of law backsliding. This is an issue which was first identified by the EU Commission a few years ago. So in 2012, 2013, we saw the emergence of a new type of threat to the rule of law. And essentially, what do we mean by this new type of threat? There's always been rule of law shortcomings in a number of countries. But what we're facing now is something of a new dimension. I like to describe it as an existential threat to the EU legal system. It's a threat also to the existence of national democratic systems in an increasing number of countries. What is so unique about the threat we are now facing is that in a number of countries, elected officials are systematically, deliberately trying to dismantle checks and balances. This is something which is not always understood, or at least not quickly enough. We are talking about a new breed of politicians who are keen to destroy democracy as we know it. How does this work? They tend to use the same blueprint, and essentially it always begins the same way. It begins with the capture of the public broadcaster and the capture with the top Supreme Court or the top Constitutional Court. It's essentially, I don't have time to explain the other steps, but essentially you end up with what we can call a soft dictatorship, where you have regular elections, but where the opposition can no longer win. So it looks like a democracy, but it is no longer one, because rotation, the peaceful rotation of power, is no longer possible. The game has been rigged. The independence of the judiciary is gone. You just have essentially fake elections, and you have a de facto, what has been described in the case of Hungary, a mafia state. So this is what we're looking at. And we have at least 2 case studies in the EU. Hungary being case Exhibit A, and then Poland, Exhibit B. But this is happening in an increasing number of jurisdictions. And to a large extent, I'm myself quite worried about what I'm seeing in the UK. I can see plenty of red flags as far as the UK is concerned. Now, what can we do about it? I'm not going to go through the many instruments the EU can use. In fact, my own diagnosis is that it's not an issue about instruments, it's an issue about getting the diagnosis right and growing a spine to do something about it. So let's not waste more time trying to argue possibly. I know the ECI is about a new instrument, but I would say because of what the Commission has just decided last week, possibly we should use our resources possibly in a different direction. So I don't want to be the bearer of bad news, but our resources are limited. We need all hands on deck, and we need to think carefully about where we can have the most impact. The ECI may have been possibly very useful, was useful until last week, but then last week the Commission has just decided that we will have some sort of a permanent new rule of law cycle. So we have to ask ourselves, do we really want to spend our time fighting for something which has been agreed? Possibly what we want is rather be part of the discussion and try to identify a pressure point which is not currently being used. By pressure point, I'm talking about something we can do which would have a short, meaningful impact to address what I call rule of law backsliding. My proposal, which has been already alluded to by Jesse from the Good Lobby, is that we target European political parties and we make them accountable for the actions of the national political parties who are engaged in rule of law backsliding in their own jurisdiction. So we have to make European political parties pay for the sins or the rule of law crimes committed by their national members. So we have essentially, what does that mean? It means we have to pressure the EPP as far as the Hungarian Fidesz party is concerned. We have to pressure the ECR parliamentary group in the parliament, which is where the Polish ruling party sits. And that's actually where the UK Tories also sit. So I'm saying, it's very good to see plenty of new energy with willing to invest this field. All hands on deck are really required. We're talking essentially about the multiplication possibly of soft dictatorships in the EU. This has to be stopped as soon as possible. And where we have to think carefully about where to focus our resources on. My suggestion would be that we leave the legal avenues and we focus on let's focus on political parties using legal means. And there is this new tool which I've been trying to activate this winter unsuccessfully, and I would need more help from all of you. There is a new tool whereby 50 citizens can write to the President of the European Parliament to ask the President of the European Parliament to open an investigation of European political parties for their complicity in the undermining of the foundational values on which the EU rests, one of which is the rule of law. So possibly that's a topic of discussion. I would say you want to have impact and possibly a lot of media coverage. It'd be good to file a complaint regarding the Hungarian ruling party, to file another complaint regarding the Polish ruling party, and pressure the European Parliament into starting an investigation to see whether European political parties are complicit in the establishment of de facto autocratic regimes in these two countries. And if this does work out, possibly, then we can expand our work beyond Hungary and Poland. So that would be my suggestion, my concrete suggestion that I'm putting on the table. Should we want to go on with this ECI, considering what has been decided last week? Or do we want to do something about European political parties? Up to you, up to us, I guess, to decide. So thank you very much.
Thank you, Laurent. So we have Virgilio, who maybe is able to speak. So let's give him a shot. Otherwise, I will read his messages. Virgilio, you want to try? Okay, I will read the messages that Virgilio sent us. So he's saying that, in his opinion, the important thing is to go on with ACI in the same case and even more than before because of what the Commission said. We have to prepare some, in his opinion, we should work on some questions for the hearing of the different members of the Commission and organize something in Brussels for that, sort of putting them under pressure. And in the new Commission, there will be probably 3 members of the Commission who are from the sovereignist. Do we say sovereignist? Populist, whatever, call them. So we risk to have a Commission that is going to be even more cautious than the one from Juncker. And so we need to go on to create a culture of the rule of law in the civil society and to push the European Parliament, where there is a vice president that is elected with the mandate of focusing on the rule of law. So that's Virgilio's take on this. And now I would say we move to our next speakers, and we open then up the space for questions and comments from all of us. So we have Wojciech Sadurski, who is a professor of, go back to my notes. So Wojciech is a professor in jurisprudence at the University of Sydney and professor at the Center for Europe in the University of Warsaw. And he's going to tell us a bit more about the Polish case, which was mentioned during the previous speeches, and specifically around the judiciary system in Poland. Thanks for joining us, first of all. We can't hear you, 1 second.
Can you hear me now?
Yes, now yes.
Okay, thank you. First of all, I need to apologize, really. I'm because I'm standing in for my colleague and friend, Professor Marcin Matczak, who asked me to stand in for him now, I really will need to leave in about actually 10 to 15 minutes. I'm really very sorry, but I couldn't have made other arrangements and I had other commitments. But I'm very pleased to see Malgorzata Szuleka present. She is very much in the middle of the storm, and she is one of the leading experts in Poland in the Helsinki Foundation, with which I also have a pleasure to cooperate. And Malgorzata will be much more knowledgeable actually about the details of the Polish situation, including an extremely important recent report of yesterday or 2 days ago, precisely by Helsinki Foundation, based on interviews with a number of judges who identify various types of forces, of pressures and limits upon their independence. So what I want to say is basically to endorse everything that Laurent said. Indeed, these two cases, Poland and Hungary, are the most regrettable cases of the rule of law backsliding, although they are quite different from each other. And in some respects, Polish case is both worse and better than Hungary. It is worse in the sense that because the ruling party, the populist party called Law and Justice, hasn't succeeded because it didn't have the requisite majority to change the constitution, much of its assault upon the rule of law have been by straight and simple breaches of law and breaches of the constitution. For example, the very central aspect of capturing or attempting to capture the whole judiciary was through a fake National Council of Judiciary, which has been basically packed by party loyalists, party faithful, in a way totally inconsistent with unwritten but very clear constitutional rules, which require that the majority of the council be actually elected by the judiciary. So we have a fake, sort of totally unrepresentative National Council of Judiciary, which is now making all the judicial appointments. So the modus operandi of PiS is quite different from that of, PiS is the Polish acronym for Law and Justice, is quite different from that of Fidesz, which has the quote-unquote luxury of establishing illiberal democracy, so-called illiberal democracy, or mafia state, as Laurent has properly called it, quoting Magyar Balint, where they have this luxury of basically proceeding in accordance with the constitution. So Polish case is worse because it shows that the party may actually achieve its unconstitutional aims without constitutional change simply by breaching the constitution with impunity. Why with impunity? Because one of the first steps which it did, according to the scenario outlined by Laurent, after taking over the public, so-called public media, broadcasting media, it has basically captured Constitutional Tribunal. So Constitutional Tribunal is a tribunal only by name. It is basically a body totally servile towards the party. On the other hand, Polish state of affairs may be seen to be better than in Hungary, because what Laurent described as probably the most regrettable or worrying aspect of these populist elected authoritarians is that they change the playing field in such a way as to make it virtually impossible for the opposition to win the election. So formally speaking, everyone can run for the election, but through a number of different devices, including gerrymandering, including other manipulations of the electoral law, including capturing the electoral commissions, including great hegemony in media, etc., etc., incumbents have basically guaranteed re-election. Now, it seems to me that from that point of view, Poland is in a much better situation, And from the point of view of the electoral chances, even though Law and Justice has huge advantage, especially through its total control of the media, nevertheless, I think that the opposition has a realistic chance of winning the election. And if it doesn't, then it has largely to blame itself for it, rather than blame the Law and Justice for making it too difficult for them to win. So really the total disaster in Poland is when it comes to the situation of judiciary. Now that there are two main dimensions of the judicial system, that is Constitutional Tribunal and Public Prosecutor's Office, has been totally captured by the government, by the Ministry of Justice directly. The big remaining field of battle is about so-called regular judiciary. That is the common judges, starting from the Supreme Court and ending with the lowest district judges. Here we have probably the most worrying instrument that the government uses is the so-called disciplinary system, which in fact is used to coerce or persecute judges on the basis of the substance of their judgments, not just extrajudicial behavior, which often is seen to be pro-opposition, but occasionally also for the judgments and for the rationale. So one may say that through the disciplinary system, which is totally dependent on the minister becomes some sort of extra appellate body, which decides which judgments are so objectionable to him that he can actually call judges and discipline them. Then you have the situation about this neo-National Council of Judiciary, which is exerting huge pressure upon judges, and we have all sorts of other forms of improper pressure upon judges, which are documented in the report that I believe Malgorzata Szuleka may say more about. For example, creating anonymous websites which actually publish some confidential documents about judges, and that's the way of attacking ad personam or ad hominem judges to basically threaten them into obedience. The judiciary is yet not fully subordinated to the minister. After all, Poland has about 10,000 judges. It's not that easy to spread the control over them. However, the trend is very worrying and negative. And the last point I'll say is that in a recent speech, the Minister of Justice said, sort of grudgingly, unfortunately, we could have pushed the reform until the end, but if we get re-elected, we'll complete the reform. And these are very ominous words, which basically indicate that they want to do with the regular court what they have already done with the Constitutional Tribunal. What can be done about it? This is basically not for me to say, but in a tiny polemic with my friend Laurent, I would say that probably if only resources are sufficient, I wouldn't put most of my attention to trying to influence parties, including EPP and ECR. The last months have shown that, especially when, ECR is a lost case, when it comes to the EPP, the last months have shown that it's very, very difficult really to influence them on anything. I think that there should be ways of influencing the Commission more directly, either through governments, through civil societies in countries in Western Europe, especially lobbying and pressuring their governments for proper behavior in the Council to make sure that Article 7 regarding Poland and also Hungary, but regarding Poland in particular, is on the agenda, because I've heard earlier today some very worrying information about Finnish presidency that they somehow take the Article 7 off the agenda. That would be disastrous. And from that point of view, I think that ECI may be a useful tool. If there are sufficient resources, I think we should look at various tools across the board rather than focus on one particular way of pressurizing. Now, again, I will stay a few more minutes, but I really need to apologize that in a few minutes I'll have to switch off, but I had these pre-arranged commitments which I couldn't cancel. So thank you for your attention.
Thank you, Professor Sadurski. Thank you very much. Now we have the meeting group in Genova who wants to say a few words and then we switch to the next speakers. So Nicola Vallinoto from Genova.
Yes, we would like to thank you for this first meeting about this new campaign. And we are local activists from two organizations, Genova Chinosa, with Stefano and other activists, and some other activists from the European Federalist movement. And we would like to say that we are ready to help in collecting signatures campaign. And if you want, in September we can organize a meeting in Geneva to present the aim of the campaign. Also inviting the promoters, Cappato, Dastoli. We are available to organize something in Geneva to help the success of the campaign. This is our contribution to this meeting. Bye-bye.
Thank you, Nicola. We are ready to be in Genova in September when the weather is probably lovely. So I will move to thank you guys and thanks for organizing the meeting. And the purpose of this distributed meeting is also to connect with each other, to know each other, and our positive effect. So thanks for being with us. I will now lend the floor to Malgorzata Szuleka. Sorry for my bad Polish pronunciation. As mentioned, she's from the Helsinki Human Rights Foundation, and today they present an important report. So first of all, I want to thank you for making the time for us, but also maybe it's a good day to talk about the work that you have been doing and that you presented today, and to maybe add some perspective on what Professor Sadurski told us so far.
Okay. So first of all, thank you so much for organizing this timely and very important initiative. And well, it's always an honor to speak after Professor Sadurski. Either I believe the bar is set very high, so I will try to deliver on the expectations. Just a brief information about the Helsinki Foundation for Human Rights. We are a Polish organization, so don't be misled by our name. We've been operating for 30 years, since 1999. Our core activity is representing the human rights, the survivors of human rights violations in the courts. We operate both at the national and international level. We do a lot of monitoring and research, part of which I'm responsible for. We also cooperate with the Fundamental Rights Agency. We also do a lot of education, both in Poland and in countries of the former Soviet bloc system. As of 2015, our plate is full because we are one of the couple of organizations in Poland closely monitoring the ongoing, something we believe to be constitutional crisis, then attack on the constitution. Now we call it similar to Professor Pech, the democratic backsliding. So Professor Sadurski just grasped the whole picture of what we are seeing with the ongoing attack on judiciary, which is the pillar for the rule of law, upholding rule of law in Poland. And judges and courts have been in the front line of these attacks for over the last 4 years. This year in Foundation, we carried out a research project which involved individual interviews with 40 randomly selected judges from 26 courts in Poland. So it's very important because this is the first qualitative research. We had some quantitative research so far. We had also some reports documenting the information that were already presented by media, but we dig deeper. We basically wanted to establish and describe what is the perspective of a regular judge in Poland trying to do their job. We identified 5 different ways of pressure. The first one, which is already mentioned, is the threat of disciplinary proceedings that are launched in politically motivated cases, but also, to our great concern, they are also launched as a sort of revenge or repercussion for the decisions judges make while adjudicating. The second form of pressure is a certain attempt to influence the decision-making process. None of the judges so far said that anyone requested them to adjudicate in a concrete case in a concrete way. However, all the changes in the courts sum up to an atmosphere in which a judge following the political situation has to realize what would be the safe way to adjudicate in a given case. The third source of pressure are conflicts within the courts. So last year, the Minister of Justice dismissed presidents of the courts in almost 150 courts in Poland and replaced the court management by judges loyal to him. So it caused a lot of, it antagonized the entire society of judges, and it caused a lot of troubles and ongoing conflicts. And sometimes we saw and we identified cases that might seem very petty, but in fact they have a lot of influence on judges' work. So for example, we saw the new court's presidents forcing the judges to move from one chamber to another, revoking the parking permit next to the court building, or firing the assistants. So this is not directed on judges, but it simply makes their life harder. The fourth issue is the media attacks, also mentioned by Professor Sadurski. And the last one, which was rarely mentioned, but it also, we think it's very much a source of a huge concern for us, is the matter of violating the right to privacy. Under the Polish surveillance law, there is no notification procedure. So even if secret services or the police use any sort of surveillance concerning one person, even when the operation is stopped, there is no obligation for the law enforcement to notify you about the surveillance. And also the court supervision of the surveillance is very weak, and it's not an effective tool. So judges are, of course, aware of that. And out of 40 judges, 25 operate under perception that their correspondence and their conversation may be tapped by someone else. In 4 cases, we identified the clear examples when actually judges had some pieces of evidence proving that the privacy of the correspondence were leaked. So was breached, and the content of this correspondence was leaked. So this is just a really short, believe me, short explanation. As I said, we've been doing this research for 5 months, and I think I can spend 5 more months to talk about it, but I think that would be against all the human rights convention. So what I'm saying is that the situation within judiciary right now is under extreme pressure. And it must be super difficult to be a judge these days, not only to maintain your regular work, but also bearing in mind the fact that you might be a public enemy, number one, in no time, and the entire propaganda machine that was already established can be used against you. So this is what the report revealed, but I also wanted to pick up on what has been already said in terms of how to protect the rule of law in the European Union. If we look at the 4 years of the ongoing constitutional crisis in Poland, we will see that nothing was effective. I mean, Article 7 procedure that was just, it swamped into sort of political bargain, and it led nowhere. Any sort of international voices and opinions and voices of concerns also led to nowhere. it seems that the governing majority was very happy to disregard them in a sense. Actually, the Venice Commission's opinions were mocked in the parliamentary debates in the heat of the changes in, for example, in the Supreme Court or the Constitutional Tribunal. Non kind of resolution, or there's no effective system of monitoring that would actually urge the governing majority to change their mind and change their policy, because as Laurent said, there is this mafia state, and one of the main sources of fuel for them to keep on going with the destruction of the rule of law is actually the strong belief in the democratic mandate and the fact that they have certain constituencies behind them. But I don't want to be so gloomy, because I would say that 99% of all the available resources wasn't effective. There's only one that pushed the governing majority to step back, and these are interim measures placed by the Court of Justice of the European Union. And it seems that only the proceedings before the ECJ seem to be the only one measures that could have somehow be accepted by the governing majority. There's just one point we are missing in this entire puzzle, is the reaction also from the European Court of Human Rights. Although the potential judgments concerning the rule of law crisis in Poland may be applicable only to individual cases, we still believe that we're still waiting for some groundbreaking decision of the Strasbourg court that may address this issue here. So that's all for what I have on my list right now. So I will be happy to explore these points further.
Thank you very much. Actually, I'm also happy to mention that among the organizations that are in touch with our group and committee, there is also MEDEL. I don't know if you know them. It's an organization of organizations of judges across, democratic judges, let's say, across Europe. So I think they have some contact points as well in Poland. So I'm happy to make introduction and just continue to build the bridges so that we connect also people in the same countries as well. So we have a short intervention from Guido Frosina, and then we will have Hilse Morgensen from London after Guido. So Guido.
So the rule of law includes the right to be cured if I am poor. Here in Italy, we had a very nice national health services that covered the needs of almost all people. Now we are losing these national health services. If I am poor, essentially I have no possibility to be suitably cured, especially if I have a serious disease. This is due to several reasons, but one main reason is that the personnel involved in the healthcare system is reducing and reducing. When this personnel retires, it is not substituted, and we have no more sufficient numbers of doctors and other jobs in this field. So the National Health Services in Italy is going to be lost. And this is a serious problem in Italy, and I think also in other countries of Europe. The European Commission gives lots of money for the health activities, but especially for those activities that are involved in creating new buildings, new walls, new hospitals. But it doesn't. The money is absolutely not sufficient to create new jobs. So this is a big problem with the European Commission, because we receive here in Genova also lots of money to build, to create new buildings, but we have no doctors, we have no scientists, no jobs, and also devices are older and older. So I think that in our initiatives we should focus on this problem. We need money from the European Commission for buildings. We need more money for doctors, for devices, for drugs. Thank you.
Thank you, Guido. Slight different angle of the topic. And now I'm happy to go back to London again, where we have Ilse Morgensen from one of the most famous organizations, which is the 3 Million. And Ilse is going to talk us about the rule of law issue and a specific situation that relates to the European non-citizens in the UK. So welcome, Ilse. If you want to tell us a bit about the 3 Millions for you know, and then your most recent campaign, maybe, I guess, you want to talk about. So,
hi, thanks for letting me join. Can you all hear? Is this okay? Great. Okay, so for part of this meeting, I've been checking social media. You may or may not have heard that we have a new Prime Minister in the UK now, Boris Johnson, who of course has a very bad reputation in Brussels, and who has just appointed the most hard right cabinet that you can imagine, and that I think has been seen in the UK for many years, including a Home Secretary or a Minister for the Interior, who was advocating the death penalty until a few years ago, and who also is campaigned for Brexit, and she campaigned for Brexit by going around to Indian restaurants, telling the owners and the workers there that, you know, when they got rid of freedom of movement and all the EU citizens had left, that there would be more visas for Indians and workers in those restaurants. So that's what we're up against. It's not good news. I mean, we may also be heading for no deal, because Boris Johnson has been increasingly saying that the UK will leave the EU on the 31st of October, no matter what. You know, we have been campaigning for protecting citizens' rights, for protecting the part of the withdrawal agreement which guarantees a set of rights, including the right to equal treatment with British people, the right to family reunion, and so on. We have been lobbying on that in Brussels and in the UK. We have been proposing it as a fallback position if there is no deal, and if the EU and the UK cannot agree on the withdrawal agreement, which has now been rejected several times by the UK Parliament. So we have succeeded in getting the UK Parliament to pass a resolution which says that they support a negotiated EU-UK agreement on citizens' rights in all circumstances, no matter what happens on Brexit. And we were just last week in Brussels talking to Michel Barnier about this very issue. We're also in Brussels this week talking to the European Parliament and trying to get as many members of the European Parliament as possible to support ring fencing and to keep raising this issue with the Commission and with their decision makers in their member states, so that we can get support for this. If you want to support us in that ask, please follow us on social media. Contact your MEP, retweet us, and so on, or contact the MEPs that you have contact with. We already have support for ring fencing from the Socialists, the Socialist group in the European Parliament, and from the GUI group. But if anyone has connections with ALDE, with EPP, I think they're not called ALDE anymore, are they? They're Renew now. Renew Europe, right? Yeah. Then it would be good if you could contact them and support our aim. We're also finding this is also relevant to the rule of law. We are finding that the end of freedom of movement, that the UK Parliament is proposing to end freedom of movement, to take away those rights that go with freedom of movement, and to force us to apply for a new immigration status in the UK. We have been pushing for the people who are already here to be automatically granted a new status, and that is one of the first things we will start pushing with Boris Johnson, the new Prime Minister, because he has promised many things to many people, but he promised during the 2016 referendum campaign that people would automatically be granted the right to stay here, and to retain the rights that they currently hold that come with freedom of movement. So he promised that we would automatically be granted the right to stay here. Theresa May put a system in place where we would have to apply. Now, if we have to apply, then we can also be rejected. Even though nobody actually has been rejected yet in the system they have put in place, it is perfectly possible that the Home Office could change those rules tomorrow. We have no legislation at the moment. We have nothing to protect us. And there is an immigration bill planned which will, as I said, take away the freedom of movement rights and make us apply for a new status in UK immigration law. So that is a fight that we are having in the UK Parliament that you should be aware of, and that we are asking the new Prime Minister to follow up on. We also have a campaign on voting rights. So very briefly, I don't know if you all heard about the scandal during the European Parliament elections, where people who were from EU 27 countries were prevented from voting in the UK. So we're all supposed to have the right either to vote in our countries of origin or to vote for UK MEPs. And to cut a long story short, many thousands of people, we don't know how many thousands of people, were prevented from voting. Extra bureaucratic hurdles were put in place. The excuse was that they wanted to prevent people from voting twice. But in practice, what the system did was prevent people from even voting once. They were disenfranchised. They were denied a vote. We've collected, we in the 3 million have collected around 1,000 case studies. So more than 1,000 people got in touch with us and contributed their stories. And we are now preparing a legal case. We want to prove that that people were discriminated against on the basis of their nationality, and we are in contact with some people who are willing to serve as test cases for that particular lawsuit. We're working with a very good law firm, and we are crowdfunding to raise money. We're almost there, and we have another week to raise funds. So please donate and promote the crowdfunder on social media. If you go to our Twitter account at the 3 million. Or our website, the3million.org.uk, there is more information about the crowdfunding challenge. We need your help to be able to do this, because it is a fundamental right that is connected with being a European citizen, and people were blatantly denied the right to vote by a British government that didn't care about well, not only didn't care, but was actively telling people to go home and vote in their home country. So, yeah, anything you can do to support and promote this crowdfunder would be a good thing. And we are also campaigning to retain the right for us to vote in local elections after the UK leaves the EU, because that is one more thing that they are trying to negotiate bilaterally. And once again, making us into a bargaining chip in those negotiations. So that's an overview of what we're doing at the moment. I don't know if anyone has any questions.
Thank you, Ilse. I'll say we finished the round of, there are three speeches more, and then we open up for questions. It's fine for you.
Great, thank you.
Thank you very much for the thorough account, which unfortunately covers a lot of aspects. So we now have Marco Cappato, who wanted to say something to Laurent. I guess it's on the ECI versus not ECI, the type of mobilization needed.
Yes. Thank you, Virginia. And I start from this last intervention, because this 3 million issue and this 3 million campaign, I think, is telling us that to deal with, let's say, populist parties in some European countries is not enough. It's not enough. Laurent was saying, correct me if I'm wrong, we have to concentrate our resources and effort on this specific issue of populist political parties, with this tool of 50 signatures raising the problem to the European Union institution. I think we should do that, and this can also be a priority. I don't think it could be the only thing to do, because the problem he was describing so well, so the erosion of democracy and rule of law, is not just a thing for Poland, is not just a thing for Hungary, but is not even just a thing for Salvini. Is a thing for, is a problem also for the more democratic countries, and for the more democratic parties. When I was a member of the European Parliament, we were responsible of trying to activate the Article 7 procedure for the first time in history, and we tried to do it with Italy. And it was not Italy of Salvini or Di Maio, it was Italy of our very democratic and friends, the ancestors of the Partito Democratico and the Forza Italia, for example, because they were both violating systematically the Italian constitution. So what's going on in the United Kingdom? Is this a fault of populist nationalist parties, or it's a fault also of the Labour leadership, for example, or the Tories, of course? So I think the problem is much wider than the problem of populist party. Is the problem of the erosion of democracy even by democratic champions. So I'm not saying that we should put everybody at the same level. Macron is not Salvini, Merkel is not Orban, and I agree that if we want to make some case, we should make the most urgent and the most blatant case of violation of democracy of rule. But to having a European citizen initiative, widespread, pan-European initiative, raising the issue in itself, and trying to give strength to the Fundamental Rights Agency, as Filippo Di Robilant was saying before. So for a systematic tool for all the countries, for all the political parties, for all the government, for all the institutions, because the problem is not just a problem for governments. In Italy, prisons are overcrowded. Justice is very slow. We are the most condemned country by the European Court of Justice in Strasbourg because of our justice. Who is the fault of this? Salvini? No. Di Maio? No. It's something that is coming well before than Salvini and Di Maio. It's something long, like 20, 30 years ago that that this situation is going on in Italy. So, as I said before, I'm not putting everybody at the same level, but to having a European citizen initiative is helpful to raise the political problem faced to any kind of power in Europe. And we don't have now resources, so it's not a problem of putting our resources into a priority, is to create the resource of a European network. And about the 3 million campaign, for example, I think it would be very useful is if from the 3 million organization, you can launch a message to your friends around Europe saying one way to help our campaign is also to support the ECI, because if Brexit will be done, one of the things that we will miss will be the possibility of go to the Luxembourg court, the possibility of sign a European citizen initiative, the possibility of asking help to the European Union. So more than the help that we can give to the 3 million campaign, because yes, we can do it. We already spread the voice with our Italian friends, but I think that the 3 million campaign can help the ECI campaign on the rule of law much more, because you are in a position of urgency and your alarm can be heard and can be paid attention to around Europe. Thank you.
Thank you, Marco. We have, I see Cesare Romano connected from the United States. I guess he's based there now. Cesare is an international lawyer and is a member of Science for Democracy, which is another organization that is part of the support committee of the ACR on the rule of law. And I asked Cesare to give us another angle on the rule of law issue, which is the right to science as a human right. So Cesare, do you want to enlighten us for 5 minutes with this angle that often is underestimated in the debate and in discourse? We can't hear you. No.
You're like a fish in the bubble.
Okay.
Nice fish.
Oh, try? Dopo. Okay, later. Okay, in the meantime, that Cesare fixes his audio, we have Lorenzo Mineo. He's an activist of our organization, Eumans, but he's also the coordinator of a organization called Radical Democracy, which I know that for some here sounds, I mean, radical has a different meaning in different countries, but maybe Lorenzo can explain us the meaning of that. And he's going to tell us a bit more about what Marco was mentioning earlier, which is the Italian case in terms of rule of law, which extends from rights to vote to a lot of other rights. So, Lorenzo. Maybe. Or the Russian bots, probably. I don't know. Okay, so if in the meantime anyone has a question or a comment or something, we can wake the eyes while Cesare and Lorenzo get ready for their speeches. Also among the discussants, if you guys heard something that the other day and you want to replicate, that's a good moment to do it.
Does it work now?
Oh, yes, Cesare.
Okay, now it works. Sorry, I just got disconnected and connected again. All right, thank you very much and for inviting me to this very interesting meeting. As I was introduced, yes, I'm a professor of law at Loyola Law School in Los Angeles in California. And in the program, I've been asked to talk about the question of the right to science. But in a true radical fashion, I'm going to do some civil disobedience. And yes, I will mention the right to science at the end, but I would like to talk about something very important and very related to what has been discussed before and what probably will be discussed afterwards, which is a few thoughts that I have about the question of the rule of law, but as applied not to the various national states making up the world, but to the international legal system. I think we are facing a very difficult moment in the life of international rule of law. As many of you know, these are days in which many countries around the world, including the ones who have been instrumental in building the international legal system as we know it, that is to say the United Kingdom, the United States, Italy, and many others, are ruled by, shall we say, colorful political characters who are completely rejecting the idea of the rule of law. They reject the idea that their power could be constrained by laws and judges. And they do that because they think that because they have been given a popular mandate to rule, they can essentially do whatever they want. Now, it's obvious that when you have that kind of frame of mind, where you're rejecting the idea of the rule of law domestically, it's not surprising then you also tend to reject the idea that there might be such a thing as a rule of law in international affairs. That is to say that the relations between sovereign states are governed by laws, and these laws must be respected. and there must be mechanisms to ensure the respect of these laws. To these people, the only thing that matters is power, not law. So if I can get away with something as a state because I'm powerful, I will do it and damn the consequences. Now, as many of you might know, since the end of World War II, the world, the international community, has built a very important infrastructure for the rule of law at the international level. This has happened both at the global level through the United Nations and the regional level through organizations like the Organization of American States, the European Union, the Council of Europe, and so on and so forth. This is the essential infrastructure of the international community, right? At the turn of the 21st century, right, we find ourselves with about a dozen of international courts and tribunals, plus a couple of dozen more of quasi-judicial bodies, which are active in many fields, including trade, human rights, general dispute settlement, international criminal law, that carry out an essential function of any rule-abiding system, which is the verification of compliance with rules and the possibility of having questions that are raised of possible violations of these rules being decided through an impartial third-party adjudication. The pieces of this infrastructure are called the International Court of Justice, the International Criminal Court, the European Court of Human Rights, the European Court of Justice, the Inter-American Court of Human Rights, and so on and so forth. Now, all of these bodies have come under attack by these populists, right? We are living in, I give you the news, in April, 3 months ago, all the chairs of the human rights bodies that supervise the implementation of the human rights treaties in the United Nations were summoned to a meeting at the UN where they were told that there's no money to fund the activities of 6 of them. That means that for the whole of 2019, 6 bodies that supervise the implementation of essential human rights treaties like the Treaty on the Prohibition of Racial Discrimination, the Treaty on the Rights of the against the discrimination of women, and so on and so forth, are not going to have any money to meet, which means that they're not going to be able to do 3 things. One, they're not able to consider the reports presented by states to evaluate whether or not they are violating their obligations. Second, they're not able to receive and decide individual communications raising questions of violations. And 3, they're not able to do the work of providing general comments on the rights protected in these bodies. This is just one example, but I could go on for at least half an hour explaining each and every human rights body and each every international court, like the International Criminal Court or even the International Court of Justice, are being choked to death, right? But I would like to echo the words of Marco. This is not a crisis that is right now. I mean, this is not a problem that is just faced because of these characters have come to power in some key states. The roots of the problem go way deeper than that. And there is a second category of people that I think are responsible for the current state of affairs. And I'll give you some surprising names. Their names are Tony Blair, Barack Obama, Bill Clinton, Matteo Renzi, and so on and so forth. These are the people who allegedly are the champions of the idea of the rule of law. But when they were in power, they did nothing to strengthen the international infrastructure to make it sure that it could withstand the assault that is currently it's withstanding. Because correct me if I'm wrong, but I don't remember President Obama pushing hard for the ratification of human rights instruments or the acceptance of the jurisdiction of the International Criminal Court when he had the numbers to do that in Congress and he had the power to do that. I didn't see these leaders deciding to allocate resources to fund these bodies so they could carry out their work. I didn't see them creating mechanisms to ensure that these bodies were protected from the threat of having their funding cuts. I didn't see these leaders actually going out of their way to ensure that at least 50% of the members of these courts and tribunals are women. They didn't do anything for that, to increase the legitimacy of these bodies. And now, of course, you know, that winter has come, we find ourselves with a blanket that is way too short to cover us. So we really need to start having a core discussion about fundamentals. Do we agree, do we truly believe that an international rule of law is necessary to ensure that the world can be a peaceful place where sovereign states not only coexist together, but cooperate for the improvement of the human condition? Or we don't care about that? And if we do care about it, then we need to start doing what it takes to build and strengthen and maintain the essential infrastructure for the international rule of law. I think I will leave it at that. If you want, I will still talk about the right to science, but I would like to now to give the chance to other people participating in this meeting to continue and to react to what I say. And I will stay online. And then if you want me, I will come back and I will talk to you about this, the question of the right to science and the activities that I've been doing within Science for Democracy and with the Associazione Luca Coscioni to promote it at the global and regional level. Thank you.
Thank you, Cesare. It was good. Thank you very much. So I don't know if Lorenzo can talk, otherwise, and still, if you want to say something, we have the last 20 minutes, so we have Lorenzo and then some time for questions, and that better is the chat on the side if you want to. I can note down the names. Lorenzo Mineo.
Can you hear me now?
Yes.
Yes, but I'm hearing my echo. I don't know why.
Very good quality.
Okay,
Lorenzo,
now it should be okay.
metti il microfono più vicino, fa schifo.
Yes?
Metti il microfono più vicino.
Oh, okay, now it's better, isn't it? Let me try without this.
Sentiamo, eh?
Baby, now is it better?
Better,
Yes.
go, parla, vai.
Fine. Okay, actually, I'll be very quick because I'm focusing in Italy a campaign on political rights. So this is something that is somehow in touch with the rule of law, with the question of rule of law, and actually, if as we should do, I think, if we focus on national issue to support our European campaign, this would be the best way to achieve the objective of 1 million signatories in Europe, because of course rule of law can appear as a very abstract subject. So in this way, by focusing on a national campaign, as the 3 million campaign that was mentioned before, and every country can have its particular issues, such as the case of the end of the independence of power in Poland and in other countries. So if we find a key aspect in every country, this could be the best way, I think, to carry on our campaign. So in Italy, we have a very strange case concerning political rights of citizens, because we have the constitutional right to submit a draft proposal of law to the parliament by collecting 500 signatures of Italian voters, and there is also an ordinary law enforcing this constitutional right. And this law is about back on the 70s. And the problem is that you can collect signatures only in the presence of a public official. This is creating a big discrimination between big parties and other civic bodies of the society, because of course political parties have a lot of public officials. For instance, local elected representatives can be considered public official, and so of course we have this paradox. Then to activate popular initiatives, traditional parties who already are in power in the institutions, they can easier accede to this constitutional right, and those who are outside the institution, which are supposed to be the one who need most to activate direct democracy, they just can't, because it's very difficult without public officials to collect signatures. So it's not a case that just in the last 9 years, only traditional parties have achieved the goal of collecting 100 signatures. So it's a paradox, and we want to carry on a strategic litigation by collecting signatures on a proposal of law in Italy, and saying that these are normal signatures, even if they won't be collected at the presence of a public officials, because our theory will be that even since we have a constitutional right to collect these signatures, even if the ordinary law says that we can collect these signatures only in the presence of a public official, well, they will be considered anyway. They should be recognized normal signatures of Italian citizens. So in this way, we want to achieve a change in the legislation, and we want to focus on a big breach of rule of law in Italy. I think that this should be done in parallel with the campaign and the collection of signatures for our ECI. And as I said before, the best way to carry on this campaign in every country is to find an issue, a topic that can be easy understand by the public opinion. So this could be a good one in Italy. It was a bit a technical issue. I don't know if it was clear.
Lorenzo.
Actually, can I jump in for a second? Because I would like to connect to something that Lorenzo just said and connects to what I was saying, right? So the question of the right to the participation of the political life of the country and the question of referendum in Italy is the object of a case that I brought before the Human Rights Committee of the United Nations in 2014, okay? The case was brought on behalf of Mario Staderini and Michele De Lucia, who at the time of the facts were respectively the Secretary General of the Italian Radicals and the Treasurer. Okay, so the case was brought in 2014. It's now 2019. The Human Rights Committee wrote me this morning to let me know that now they're ready to move on with the case after 5 years, right? And in the same email, they also told me like, and by the way, we cannot find the CD that you sent us when you filed the initial communication with all the evidence. So after 5 years, they're waking up and they're asking me to resend them the evidence that is attached to the communication. I don't blame the United Nations. That office has only 15 people who are handling the caseload for all UN human rights bodies. And they have a backlog of thousands of communications. They're doing what they can with the very few resources they're given. But it's politically cynical on the parts of states, on the one hand, to accept that they have human rights obligations and ratify the treaties, and then to deny the bodies that are supposed to supervise implementation of the treaties the resources that they need to do their job. It's a cynical political game. And again, it's a game that has been played both by the obvious enemies of the system, which are the ones that are currently in power, but also by the people who are allegedly the champions of the international and domestic rule of law. So, Lorenzo, if you do that case, strategic litigation, and you end up not prevailing before the domestic courts in Italy, know that we are ready to bring the ball to the next level and try again at the UN level. Okay, so we got some teamwork.
Okay, very good. Thank you very much, because we will probably need your support. You know, we need your expertise, of course. So
okay,
keep in
great.
touch.
So we have Filippo Di Robilant who wants to say something, and then I have myself a question for Malgorzata.
No, just very. Thank you very much. Just briefly, because I must leave. Just one sentence. Please don't kill the ICE even before it takes off. Even if you want to target political parties, very well. The ICE is a way to pressurize politics, just political parties, just by asking if they want to join or not. But I repeat, I don't think, I mean, it was a very interesting conversation. We said a lot of things, but at the end of the day, please don't kill the ICE. Thank you and goodbye.
Thank you, Filippo. I have a question for Malgorzata about the situation in Poland. A report like the one that you publish, how it gets accepted by the media and also by the so-called civil society or society in general. I mean, I'm interested to understand the impact of this type of activities, which is super important, but what are the reactions in the country about something like that?
So we live in a deeply polarized society. So the line of the conflict actually is either you are with the government or either you are against the government, which is super difficult for organizations like mine, because we've been a watchdog organization and this is in the DNA of our work. So we've been criticizing all the governments since 1999. And we do acknowledge that this one actually caused a lot of harm to human rights and rule of law, but it doesn't mean that the situation was perfect. Until 2015, we were quite recognized for that, but after changes in 2015, when the media market polarized, we are either defenders of human rights or Soros-paid agents. So today, when it comes to the media reaction to the report, we had the whole spectrum. So first, the far-right news portal started with article insulting us, saying that the report is a manipulation, that Soros paid us $1 million. By the way, I wish I could see that money. But this is the same propaganda we saw in Hungary or in Poland, that Soros paid for the people attending the protest against the changes in the reform of judiciary. And the other side of the media, well, they reported on that. Civil society, I think, hasn't reacted yet, but our main target with this report is not only civil society, it's not only judges. We believe that this report may be valuable in some years to come when we will have to restore the rule of law. I truly believe that at a certain point we'll be able to do that. But for the moment, in a short distance, actually, our main target groups are European institutions. We wanted to show the growing pressure and hoping that that might force the European Commission to move further with the infringement procedure on disciplinary proceedings. Also, we hope that it will be a red flag for other legal professions in other EU countries. So you can expect, in a case of attack on the rule of law, you can expect what may be next in your countries. And finally, There will be a follow-up to this report. We will try to prepare a guidebook for attorneys working in the EU, those working on the European arrest warrants. We will try to somehow make the Selmer test set by ECJ last year make a living instrument and something they can use in their litigation. So just to summarize, I think the report was acknowledged and the media reported on that, but on the one hand, the propagandist media say that this is just a manipulation, and on the other hand, you can hear voices that this is something we can expect it. So we could have expected. So we will see what will be the next steps in next stages in this discussion.
Thank you, and I think it was interesting also to hear the willing to reach to the European institutions even more than the local. Like I think it's an interesting approach. So we have the last 6 minutes. So Guido, you asked to talk, so 1 minute, so then we can go to the conclusions.
There was a guy a few years ago that thought about the erosion of democracy and the methods to prevent it. This guy was Montesquieu, who said that the main antidote, counterpoison, to avoid erosion of democracy was the separation of powers. Have you never thought why in Italy we cannot have a law on the conflict of interest? That is simply because all parties are not interested in such a law. And also, have you never thought why the jurisdictional power, the times of the justice are so long, and they never shorten if the government is left-wing government, right-wing government, a center government, because it's of interest for everybody that the justice is low as inefficient. So the most direct way to avoid the erosion of democracy is that the legislative power, the executive power, and the jurisdictional power are reinforced. All three are reinforced, and that no one overcomes over the others. Thank you.
Thank you, Guido. No other speeches. So, Marco, do you want to say something? I think Virgilio left. Otherwise, I will just wrap up.
No, the only thing that I wish to say is that it's a good thing that we did not have an organizational debate, because before, in a way, before becoming operational, it's very important to discuss and reason the deep motivation for what we are doing. So this is very good. I think that the European Citizen Initiative has the advantage of involving directly citizens, not just NGOs, experts, jurists, or activists as we are, but is an instrument with the ambition of touching public opinion at large. So I think we should maintain this approach. I would like to underscore, I don't find it alternative to what, for example, Laurent has proposed, or to the 3 million campaign support, or to idea of helping disseminating the report about Polish justice. I think we should do all these things, and in doing these things, we should accompany this activity with the request of jumping in the campaign, because the two levels are mutually reinforcing. So I think we should have also an operational follow-up on who could be available in starting collecting signatures, because this is also important. So without discarding the importance of touching on specific issues as we did tonight. I think that, for example, also these things that Cesare Romano was saying about the lack of resources for the international justice mechanism, I didn't know. Well, I had some knowledge, but I didn't know in such a precise way. And I also think that it would be very helpful if Cesare transform his speech in an article and to try to give the maximum dissemination as possible to this alert that he launched during this meeting.
Thank you, Marco. Maglio, you asked for 1 minute, but it should be 40 seconds, and then we close it.
Thank you. Well, I wanted to finish on a positive note. I think one good news is that we're all here today talking about the rule of law, and the fact that we're activating is positive. I think the European Citizens Initiative is going to be a marathon, and we need to run that marathon alongside a number of sprints, and those sprints are going to be those use cases and those campaigns which are affecting the rights of citizens, which are part of the rule of law umbrella. The approach of naming and shaming the political representative and the cases where the rule of law is threatened is very powerful and allows us to single out specific cases which bring to life why the rule of law is important. So I would say let's get on our marathon and be ready to run some sprints alongside that marathon.
Thank you, Coach. Thank you, Maglio. So now I think it was very helpful to have the more analytical and theoretical element and the actual cases. And thanks everyone for joining in this super hot day around Europe. We do have an ACI also on climate change, so maybe I will let you know about that. No, thanks everyone. I will follow up with the discussants and all the people that attended the meeting so that we can understand how we can help each other to, first of all, increase the knowledge of the activities that we do, and also how we can help, if you want, how you can help for the campaign. The next appointment is most likely to be in September in Brussels with an official launch of the actual collection of signatures, but there will be other activities, and for those of you who want to be informed, let me know. We have all the addresses of the people that subscribe to the event, so they're going to receive updates if they wanted to, otherwise not. Thanks everyone for joining and enjoy this evening. Thank you.
Grazie. Ciao a tutti. Thank you. Bye-bye.
Bye.
Thank you. Bye.
Bye-bye. Thank you.